Hello, this is Vanessa Gordon with Gordon Law in Lincoln, Nebraska, and today we're going to talk a little bit about the top 10 myths involving divorce proceedings in Nebraska. These are in no particular order, but are the top 10 misconceptions or myths that people tend to believe before they have an opportunity to discuss the process and the facts that are important with an attorney. The first one we want to go over is that it matters who files first. There are some limited situations where being the plaintiff or the filing party in a divorce may be helpful, particularly if there is a need to control timing of service, of process on the other party, or a need to have some temporary motions because of something that is going on that requires immediate attention before achieving the final orders in a divorce or during the waiting period. So there may be some benefit to controlling the timeline in certain circumstances. But for the vast majority of cases, it does not matter who is the plaintiff or the defendant, and there's not necessarily a legal advantage or a way that the judge views being the filing party versus the non-filing party. That would be number one on our list today. Number two would be that it matters if your spouse is a bad person or is at fault. Nebraska is a no-fault state. So things like adultery and even to some extent substance abuse or lifestyle choices or sexual orientation or dishonesty during the marriage, any of those types of behaviors by themselves do not have any effect on the application of the law or how the court would view the ultimate requirements for dividing the property and assets and debts of a marriage. There are certain behaviors that could be considered bad acts that would affect the judge's rulings, including financial draining of assets or property damage in a vengeful capacity. Those types of behaviors would potentially be fault that the court could consider. But as a general rule, Nebraska is a no-fault state and it does not matter. Another misconception is that Nebraska is a mother-friendly state and mothers have an automatic advantage in obtaining custody of their children. As a general rule, the entire state custody courts have moved more towards a presumption that if the parents have been married and residing together with their children for a period of time, both parents are fit parents, and some form of joint custody should at least be before the court are considered. And in fact, statutorily, the judge can consider joint custody even if both parents ask for full custody. So there is definitely a movement towards ensuring that children have roughly equal access to both of their parents, unless there is a strong reason not to, such as a spouse who travels out of state for work or who has an active substance abuse issue or safety issue that would prevent that from happening. The fourth misconception or myth would be that children can choose which parent they wish to live with or what their visitation schedule should look like. Children under the age of 19 years old in Nebraska do not get to make the decisions about where they visit or who they live with. That's going to be decided by the parents, and if the parents can't decide, it will be decided by the courts. It's not sufficient to say, well, my child is 16 or my child is, 10 and very smart, they should get to decide. If the child has sound reasons and is of sufficient age and maturity, the court can take what the child has to say into account. However, ultimately, the adults or the judge will be the one to make the decision. The next misconception or myth is that everything in a divorce must be divided exactly in half or 50-50. Nebraska is an equitable division state, which means we generally consider 1/3, 2/3, or 50-50 split of assets and debt to be patently fair at first consideration. However, there are often divorce divisions and settlements, even orders at trial, that are not a straight 50-50 division of all assets and debts. It's a fact-specific scenario, and the court takes into consideration ability to provide for children, earning capacities, choices for contribution into the marriage, any premarital assets or debts that need to be set aside, what debt was incurred for, and who benefited from that. There's a whole lot of considerations that are very fact-specific that go in, but it's not an automatic straight down the line 50-50 division. Another common misconception or myth is that support and visitation for children are linked. You cannot have a parent denying visitation with a child because the other parent is not paying child support. And likewise, you can't demand visitation purely because child support is being paid. Those are considered two separate issues by the courts and are considered 100% separately. Another common myth or misconception is that divorce orders are easy to change later. They are not. Property settlement and debt division is final 30 days after entry of decree and cannot be changed. Another misconception is that your divorce decree is good as to third parties. Your creditors are free to come after whomever they're able to legally pursue for their debt, and it does not matter what the divorce decree says. The divorce decree is only good as between the two parties who are subject to that divorce decree. But also, if those orders need to be changed later, property and debt is done after 30 days after the decree. Parenting time, custody, and child support can be modified, but the trend is towards a much higher standard for what would qualify as a material and substantial change in circumstances. Children simply getting older or something that could have been in the contemplation or potential consideration for the parties to the divorce at the time the decree is entered does not generally qualify as a material and substantial change later. Another issue would be that divorce that's between two parties is going to go exactly like a divorce that the parties know about. So your neighbor, your sister, your coworker, all of the stories or understanding you have of a divorce filing that isn't yours does not have any bearing at all whatsoever in how a judge will view your case. There's so many fact-specific things to consider in determining the likelihood of certain outcomes in a divorce, and that includes who the judge is. Even if you have the same judge, however, your neighbor had a judge for a divorce and then you have that same judge for the divorce, that does not mean the judge is going to view your specific facts the same. I also like to remind my clients and potential clients that you hear one side of the story when your neighbor talks to you about their ex-spouse or how their divorce case went. You do not hear an objective version of the facts. So you may hear your coworker say, well, I didn't get custody of my children because Nebraska favors the mother. Right. And as we just discussed, that's actually a myth. That's not the trend currently in jurisprudence in Nebraska for custody. However, what your neighbor may not tell you is that they picked up a DUI while driving with their children in the car. They're not going to share the bad facts that may have led to an adverse decision, and they may, as we often do as humans, exaggerate or misstate certain facts. And the simple truth is often we don't know what the judge relied on in their case unless you were the attorney speaking with the judge as the judge made the decision. Finally, I think that this one can be a little bit of a harsh truth, and so I've saved it for last. One of the myths or misconceptions that parties have to a divorce is that the judge cares about your story. The court doesn't care about your story. The judge often doesn't even know your children and will never meet them. The judge has no way of catching up on the history of your life prior to coming into court. And usually the judge is the person in the courtroom who knows the least about you. The parties to the action know the most. The attorneys have usually educated themselves and worked with the clients to learn. The judge has only very, very limited information, and the judge only cares about your story to the extent that it has a legal significance. That's why it's so important to work with your attorney. A lot of times the facts that you think are very important and may be very important to you are not facts that the court can even consider when applying the law to your situation to make a determination about, your property or your debts and assets or your children. And so the things you may wish to tell the judge to have your day in court may not actually accomplish the goals that you have for your representation. That's why it's always worth it to make sure that you have a good relationship with your attorney and that you trust your attorney to guide you through the process. So there's a quick view of the top 10 misconceptions or myths involving divorce in Nebraska. I hope this information's been helpful to you.